All right, welcome everybody. My name is Lori Luzader and I'm the Executive Director of Special Kids Connect. We are a family resource center in Monterey County, serving the needs of families who have individuals of any age with developmental disabilities or any type of disability. And joining me tonight is Jose Francisco Hernandez Rivera. Jose is our Community Services Director. And this is the fourth in a four-part series on in-home supportive services, advocacy, and information. We are super delighted to have Disability Rights California with us for this fourth session. And with that, I'm going to pass the baton to Maria and Mary and let you guys introduce yourselves and a little bit about Disability Rights California.
Hi, good evening. My name is Lonnie Pfeiffer. I'm with Disability Rights California. On behalf of our senior attorney, Maria Riarty, and our senior advocate, Mary Rios, for those who don't know us, just share a little bit about our agency. We were formerly known as Protection and Advocacy. We are a nonprofit organization that provides free legal services to people with disabilities. We have offices in Sacramento, Los Angeles, Bay Area, San Diego, and our smaller offices are Fresno, Modesto, and Ontario. We work on issues such as special education, regional center services, public benefit, housing, mental health services, employment, ADA, and so forth. At this moment, I'll go ahead and turn it over to Mary Rios.
Thank you, Lonnie. Good afternoon, everyone. My name is Mary Rios. I'm one of the senior advocates at Disability Rights California. And again, we are happy to be here. Thank you, Lori and Jose, for inviting us once again. Maria is going to cover today what happens after the notice of action. And if I'm going to put my information in the chat, if you would like an appointment to speak to Maria, feel free to call me. It doesn't have to be necessarily on IHSS. It could be on any of the issues that Lonnie mentioned. And with that, I will go ahead and turn it over to Maria.
Great. Thank you, Mary. So big question mark, like what happens after I get the notice of action? So today we're going to go over what a notice of action is, what it means to have an adequate notice of action, what it means to get a timely notice of action. And we're going to use a hypothetical of a child whose supervision is going to be terminated. And we're going to see how mom prepares for the hearing, what happens during a hearing, typically the things that happen during the hearing, who's at the hearing, and then a couple of things that may happen after the hearing. So we're going to go ahead and start with Emilio. So his mom gets a notice of action from the IHSS program with the date of April 1st of this year, saying that they're going to terminate Emilio's protective supervision because there are two reasons that the notice of action gives for the termination. Because he's self-directing and because he doesn't need 24/7 supervision. So Emilio is 12 years old. He's a person with autism and auditory processing disorder. So mom reads the notice. She understands the reasons but she doesn't really understand. She understands the 24/7 supervision, but she's not quite sure what it means that he's self-directing. She's never really understood the protective supervision program and really doesn't know what the criteria is for. She didn't know that there was specific criteria for eligibility. But in any event, you can understand how upset she is at receiving this notice of action. And so she reads the back of the notice of action and she sees that she has 90 days to appeal the notice of action from the date of the notice, but if she doesn't want her son's protective supervision to terminate before there's a hearing, the notice of action does say that she can appeal before the effective date of the notice, and we're going to see what that is later on. And she must ask for aid paid pending so that nothing changes until there's a hearing decision. And if she wins, of course, nothing will change, right? So that's what she does. She appeals the notice of action by calling the State Fair Hearings Office and asking for an appeal orally. But let's step back for a moment so we can understand what a notice of action is. A notice of action is a document that you receive that explains whether or not you're eligible for a program or services, whether services are going to terminate, reduce, and it's legally required that people who are on public benefits, such as IHSS, receive a written notice of action. Not just any old notice of action, it has to be adequate. And adequate notice is a legal term. And what does it mean? It means that the notice has to tell you what the county intends to do. So here, the county is terminating Emilio's protective supervision, the reasons why they're doing it. And they gave two reasons: that Emilio is self-directing and that he doesn't need 24/7 supervision. And it has to show the laws and regulations that support the county's actions. So there's got to be information there. Maybe they're going to cite to the regulations, which in IHSS are called the Manual of Policy and Procedures, or MPPs for short. Anyway, the notice of action has to provide that information. And importantly, also an explanation on your right to a hearing. Like I mentioned before, when mom read the notice of action, it says she has 90 days from the date of the decision. But if she wants aid paid pending and she doesn't want anything to change until there's a hearing decision, there's something special she needs to do. So let's look at, this is sort of a close-up of a notice of action. On the top right part of the notice of action, you're going to see a date of notice of action, and the date is April 1st. And then there's a rectangle here that says as of May 1st, so a month later, the services that Emilio is going to be getting will be reduced, the protective supervision. So this date, May 1st, is called the effective date of the notice, when things will happen, when the change will happen. It's not the notice, not the date of the notice, it's the effective date of the notice. So if mom appeals before, if mom appeals before May 1st and she asks for aid paid pending, you have to ask for it, then nothing will change. When May 1st comes around, Emilio will continue to get his protective supervision, and then until there's a hearing decision. And if it's favorable, then he continues to get it. So this is really important. Now, if someone has never been on the IHSS program, you can't really ask for aid paid pending because you were never on the program. There's nothing for you to stop changing, right? So this is for people who are on the program already and something is going to happen. They're going to be terminated, services are going to be reduced, eligibility is denied, whatever it is. So the notice of action will also might even have some language about what the county still needs. And so if you have a notice of action that says, the county hasn't received such and such a document, well, then you should submit that document to the county and maybe they'll issue a new notice of action with a more favorable outcome. If you have identified to the county your need for notices to be in your native language, if the language that is spoken in your county is spoken by at least 5% of the population, that's a threshold language, and the county is required to be language compliant. So mom, in this case, although she speaks Spanish, she also understands English. And so she's never asked her county social worker to provide notices in Spanish. But that's important because people need to understand what's happening, right? And what their rights are. to appeal. There's also another term in the law called timely notice. So your notice of action has to be mailed to you at least 10 days before the effective date, because that's the law. So, if you get your notice of action after the effective date, that's not timely notice. So it's really important that that happened, because if you haven't gotten timely notice, if you want to appeal, you can call the State Fair Hearings Office and say, I want to appeal. And by the way, I want aid paid pending because I never got timely notice. So you would have to explain that to the State Fair Hearings Office. So that's another concept. Additional information on the notice of action. Those of you who have attended my other trainings will know that the notice of action has in the first column, the services, and then deductions for proration for alternative resource hours, and then the total hours. So there's lots of information on that IHSS notice of action. Now, when you're asking for a fair hearing, there are things you should be thinking about. If you need an interpreter, you should ask for it at the time that you request a hearing. You could ask for an interpreter at any time, even when you're in the hearing. Let's say, for example, that you thought that you could do the hearing in English, but when you're in the hearing, you realize, oh my gosh, I really don't understand what's going on. I'm not capturing a lot of what is said. You can always stop the hearing and ask the judge for an interpreter and just say, look, I'm not understanding what's happening. And either the judge will get an interpreter right away. And if the judge can't get an interpreter right away, the judge will continue the hearing. So there's another session with an interpreter. Don't be shy about it. I was in a hearing, my last hearing. We just kept on getting really bad interpreters. It was a Spanish interpreter, and I speak Spanish, so I could tell that it wasn't being done properly, and I would have to interject and object. So did the county. And we went through at least 5 interpreters. We had to continue the hearing a number of times because we were just getting really bad interpreters. They could be really bad. And it's really important that your testimony be correct, right? And so if the interpreter's not doing a good job, the information may be wrong, and the judge will base his or her decision on the information, what was translated or interpreted. So it's really important that the interpreter be a good interpreter, and that you interject at any time during the hearing if you feel that that's not that the interpreter is not doing a good job. If you need a reasonable accommodation, let's say that you have a disability and you require a little bit of rest every half hour. Well, you're going to ask for reasonable accommodations to the State Fair Hearings Office, because typically these hearings are scheduled for no more than 2 hours, and that 2 hours can go by really fast. And if you don't finish your hearing within the 2 hours, then the hearing is continued to another day. There are hearings that could be 3 or 4 or 5 day hearings, just they've been continued because they weren't done in 1 hearing or 2 hearings. If you need any type of accommodation, you should ask for it. If you want to subpoena documents at the hearing, documents you realize the county is not going to bring into evidence, or that you can't get unless you issue a subpoena, or you want a person to come and testify at the hearing, and this person isn't going to come voluntarily, you can ask the State Fair Hearings Office to allow you to issue subpoenas for documents and or persons. You can continue the hearing. So let's say, for example, your hearing is set for next week, but you just are not ready. You're still waiting for that doctor letter. You're still maybe looking for representation. You just don't feel that you're ready for the hearing. You can call the State Fair Hearings Office and postpone your hearing. Now, the first time you postpone, not too much of a problem. They'll ask you why, but every time thereafter you want to postpone your hearing, you're going to have a really good reason. Hearings by law are, you have the right to an in-person hearing. During this time of COVID, that was done away with, and we were having phone hearings and video hearings, but you can insist currently on an in-person hearing, although the State Fair Hearings Office, I just requested a hearing this morning and they said to me, well, do you want a phone hearing or a video hearing? And I didn't care to have an in-person hearing, so I said, I'll have a phone hearing. But, just know that you have a right to an in-person hearing. You can even have your hearing at home if you're if the beneficiary, the person who's receiving the service can't get to the Fair Hearings Office and wants to participate. You can ask for the hearing to take place in your home or another place. Expedited hearings. Oops. If you need it, it's going to take time to get your hearing. From the time that you ask for a hearing, it could be 45, 60 days maybe before you get a hearing date. But if you feel that you need to expedite your hearing, you can ask for an expedited hearing to get it sooner rather than later. But remember, there are a lot of people waiting in line for their hearing dates, and you're going to have a really good reason to expedite the hearing. I talked about the length of the hearing, so that's important to know. So once you've requested your hearing, the State Fair Hearings Office, now the State Fair Hearings Office is located within the California Department of Social Services, but it's its own department. And they hear IHSS hearings, Medi-Cal, CAPI hearings, the kinds of benefits that are administered by your local Department of Public Social Services offices. They're going to send you a letter saying, we got your appeal. You're going to be hearing from the appeal specialist, who is the county employee who's going to represent the county. They are not attorneys. They're probably people who have worked in the IHSS program and maybe have been promoted to that position. So you'll get a letter from this person. And you will get a letter from this person saying, hey, I'm the appeals rep. I'd like to talk to you about the case. I always say to people, talk to them. It's really important because it's an opportunity to try to settle the case before going to hearing. And even if you don't settle the case, it's a really good opportunity to get information from them as to what, more of an idea as to the reasons why they did things, right? Or the evidence that they're relying on to at the hearing for what they're going to do. And then you're going to get, after you get the letter from the appeal specialist, you're going to get a letter from the State Fair Hearings Office with the date, time, and place for the hearing. And that's typically what communications you'll get. So procedures for, what you do at a state hearing, how to issue subpoena, how to get continuances are found. There's information about State Fair hearings in this first link, and you'll find general information there. The regulations concerning the procedure that you need to follow for fair hearings is found in the Manual of Policy and Procedures. These are the regulations starting with 20-000. And you'll find it in this link. You'll find all of the procedures. There's also something called the bench book. So it's the judges use this bench book to decide how to handle situations, right? Let's say how to handle a request for a subpoena while you're in a hearing. How do you deal with disruptive witnesses in the hearing that's taking place? I don't know, Lonnie or Mary, if you can just open up the bench book so we can just show them. I can stop sharing so that people see what this looks like. I use it because if I want to ask the judge or the State Fair hearings for something, I want to see how they would handle it. And I want to tailor my request, to to address how they would handle it, what kind of evidence they would need. So if someone wants to postpone the hearing, if someone wants to disqualify the administrative law judge, how does the judge do that while at the hearing, right? What if someone requests aid paid pending while you're at the hearing? What if someone abandons the case? Someone who filed for a fair hearing doesn't show up. So, it's called abandonment. And so how much time must the judge wait before the judge says the person has abandoned the hearing? And what can you do if you didn't appear at the hearing to reinstate the hearing? So there's a lot of information here, withdrawals if you want to withdraw. So these are all procedures, right? How to do things, all related to a state fair hearing. And thank you, thanks for that. And the manual of policy and procedure also.
Maria, you're on mute.
Oh, sorry, because there are procedures that need to be followed, right? And so where do you find them? And they're in the regulations or the bench book too. Okay, yeah. So what is the first thing that Emilio's mom needs to understand? She needs to understand why she's going to the hearing. So where is she going to get that information? The notice of action. So she knows that she's going to hearing because the county is wanting to terminate Emilio's protective supervision because they say that he's self-directing and that he doesn't require 24/7 supervision. That is the issue at the hearing. When you're at the hearing, you're off and start to talk about other issues, the judge is going to stop you and say, I don't have the jurisdiction to hear those issues. Those issues are not before me. The only issue before me is the termination of protective supervision. So if you want to air your grievances against the county for everything they've done to you in the past, it's not going to work. Focus on why you're at the hearing. Focus on what you need to prove to get what you need. And in this case, mom needs to make sure that Emilio continues with her protective supervision. Another way of getting information is also to talk to the appeals specialist. You can get a lot of information about the case just by talking to them. Of course, they can do the same when they talk to you, right? So it's a two-way street. I find it always very helpful to talk to them. You have the right to review your file. So the Manual of Policy and Procedures 20-051, remember, they're found here. Whoops, they're found right here. You have a right to review your file. So one thing you might want to do when you know who the appeal specialist is, or you can reach out to your social worker too, is just say, hey, I want to review my files. How do we coordinate that, right? But also know that 2 days before the hearing, the county has to give you their position statement. And that's a document that explains to the judge what they've done, the law they've relied on, right? And why they're doing it. And the evidence that it's going to present at the hearing. So 2 days before the hearing, you're going to have that information. But you need to coordinate with the appeal specialist how you're going to get that information. Do you want the appeal specialist to email their position statement to you? It used to be when the county offices were open, you could just drive over and pick up the county's position statement, but you can have it maybe faxed to you, but don't just wait for it to happen. You have to have a conversation with the appeal specialist as to how they're going to get it to you. It's really important. But by the time you get the county's position statement 2 days before the hearing, hopefully you're well prepared and you're just reviewing the county's position statement to see if there's anything you need to bring up at the hearing that is in the evidence, right? Maybe you want to cross-examine the social worker about something that's in the assessment, something that the social worker said, for example, you said, but you didn't say that, or maybe things that are missing from the assessment that you told the social worker and you asked that you could cross-examine would be something like question to the social worker, you were at the reassessment. I told you this, and this, but why is it not in your assessment? So it's kind of that kind of thing. So Emilio's mom knows what the issue is, right? And she's going to focus on that issue at the hearing. The next thing that mom needs to do is understand the law on protective supervision. Now, there are two reasons that the county is given in its notice as to why they're going to take the protective supervision away. And they've cited to MPPs, so mom could look at the MPPs to see what they say about protective supervision. The other thing she can do is go to that all-county letter, 15-25, where it talks about protective supervision in minors, and it provides the 4 criteria for minors to get protective supervision. One, that the child has a mental disability such that they are non-self-directing. They don't understand that what they're about to do will cause them injury. 2, that the person requires 24/7 supervision. Sounding familiar? 3, that the child has the capacity to get into harm. And 4, that the child of that age needs more supervision than a typical child without a disability of the same age. So of the 4 criteria for protective supervision, the county is saying that Emilio doesn't meet 2 of them. They're saying he is self-directing. They're saying he doesn't need 24/7 supervision. So suddenly mom understands why that information is in the notice of action. Suddenly she understands that protective supervision is more than saying my son has autism and auditory processing disorder and he needs to be supervised. It's more than that. There's criteria. So now she knows that that's two of the 4 criteria are the ones that the county is focusing on. So what is it she needs to do next? So this is it for minors. For an adult, you don't have to show the 3rd one. You don't have to show that an adult needs more supervision than an adult of the same age. You don't have to do that. But otherwise, the criteria is the same for children and adults. Children just have this extra one. So mom now knows. So now that mom knows and understands what the law is on protective supervision, she has to start to gather evidence. She has to show that her son has a mental disability that causes him to be non-self-directing, in that he doesn't understand that the behaviors he's going to, what he's about to do or is doing is going to cause him injury. So how is she going to do that? She could look to the IEPs, maybe the triennial, maybe the IPP has information on his disability, and maybe there are examples of behavior situations where it's clear that the child is non-self-directing, that the child doesn't understand that what the child is about to do or is doing will cause them injury. Maybe there's information in the IEP about the child banging his head against the classroom table and won't stop, just won't stop, and the need for intervention. Maybe the child, elopes from or wants to leave school or tries to elope. The child doesn't understand that by doing that, he may become lost because he has no sense of direction or where he is. So hopefully the IEP and the IPP will support the fact that Emilio, that his disability makes him non-self-directing, and that he has these behaviors. Another thing to do would be for mom to get a letter from his doctor explaining. Now, a doctor letter that says this: Emilio has been my patient for 5 years. He's a child with autism and auditory processing disorder. He needs supervision 24/7. If you need any information, please contact me. That's not a very good letter for Emilio. A better letter for Emilio would be the doctor actually addressing Emilio's mental disability, explaining it, and explaining why these disabilities make him non-self-directing. I helped a doctor prepare a letter for a protective supervision case where the doctor addressed the criteria that was in question, and also examples of things that the mom had told the doctor, these behaviors, right? And it was a really great letter. It was, there was a lot of good information, because with protective supervision, you have to talk about the behaviors. You have to give a story for each incidence, right? Like, it's really important because the behaviors tell the story. So this child would, be watching, mom was in the kitchen and child was watching TV, also using the iPad, and suddenly the child started to bang the iPad against his head and wouldn't stop. And mom had to intervene. She had to do sensory therapy, and it took 30 minutes to calm him down. And when he did, but you describe it in as much detail as possible. And then you start to understand how his autism or his auditory processing disorder makes him non-self-directing. Now, in the case that I did, the child he was doing really great in school. If you didn't know he had these disabilities and you spoke with him briefly, you wouldn't know, right? You just wouldn't know. But because of his autism and auditory processing disorder, he has triggers. And some of the triggers are known. They're known triggers. They know what will trigger him. And some of the triggers are unknown at any time. He could be triggered by whatever event. And he goes into a non-self-directing mode where he'll start to have repetitive behaviors that could cause him injury. And that's how the way the doctor described it, right? Yes, but he suddenly gets into this mode. And in one example, the mom said, when he came back, so to speak, because he kind of wakes up from this, he asked his mom, there was a hole in the wall because he had hit his head so hard that there was a hole in the wall. And he said to his mom, what happened here? Who did this? Like, he didn't really understand what had happened, that he was the one who had done it. So you see how important it is to talk about, like, in detail about what happened that day. Really important. The SOC 821 is a form that the county is going to say that they need from Emilio's doctor. Mom had already provided the form to the county, but what the form wants to know is about memory, orientation, and judgment, whether it's mild, moderate, or severe. And the doctor will check it off and maybe put some comments, and the county will use it as evidence. It's not determinative of the need for protective supervision. It's just a piece of evidence with all the other evidence that the county will gather. And based on all the evidence that the social worker looks at, including the SOC 821, the social worker will determine whether the child needs protective supervision. If Emilio has an ABA provider, maybe get a letter from the ABA provider about observations and behaviors that the ABA provider has observed. If the ABA provider doesn't want to do that, at least get the records of the sessions, because there's going to be information there about behaviors and what happened. And, so that could be a really good source of information. You can get witness declarations. A declaration is it's a document signed by the witness under penalty of perjury. It's testimony. It's written testimony as to what the witness would say at the hearing about. And so maybe mom could get declarations from neighbors or family friends who have observed behaviors, non-self-directing behaviors, and talk about it in detail. Because witnesses can talk about what they've observed, right? You can either get a declaration, or you could have the witness appear by phone. You can, at the beginning of the hearing, you can tell the judge, I'm going to have 2 witnesses and this is their name and number. And when the judge is ready to call the witness, the judge will call the witness and get testimony by phone. Or if you're going to do an in-person hearing, you can also have the witness there in person. I did a hearing a long time ago where my client's child, the plastic surgeon, was going to testify by phone. We called him up and he was in the middle of surgery. And I'm like, oh my gosh, now we're going to have to continue this hearing so that, because I needed his testimony. Well, he stopped the surgery and got on the phone and gave his testimony. I was in shock. I don't know what he was doing in surgery, but he did it. But if he hadn't been available, we would have had to continue the hearing to get his testimony. Sometimes what happened at the home evaluation is important to talk about at the hearing. You might want, when you're having an evaluation, you might want to have someone present to write down what time did the social worker arrive at the home, what were the questions that were asked, what were the responses, how much time was spent really talking about the needs of the person versus filling out forms and signing forms. I've done this in the past where, we had a case where the mom we got the position statement and the IHSS social worker's evaluation, and mom had told the social worker about new behaviors. That information was not in there. And there was wrong information, but mom had told the social worker things, and the information in the social worker's assessment was wrong. And so mom prepared her own declaration with her testimony as to what happened at the home evaluation and what she said and why it's not, and that it's missing from the assessor from the notes. And it's important, to bring that up sometimes. A hazard log. If mom hasn't been hasn't been working on a hazard log, maybe it's time for her to do that. She documents on a day-to-day basis all the behaviors that have happened during the day. What happened? How did she have to intervene? Was he injured? Was he not? You don't have to be injured to get protective supervision, because the whole point is to prevent the injury. So those could be very powerful introduced at the hearing. Regional centers have a form called the CEDAR, and it provides information on the client, the functioning level, information on the disability, memory, judgment. There's a lot of good information that you can get from the CEDAR. So you could ask the regional center to provide that. You can even ask the regional center. I've done this before where I've asked the service coordinator for a letter describing why the child or the person meets the criteria for protective supervision, the criteria in question, because regional centers could have a lot of good information. And that's why it's important when you're talking to the regional centers or the IEP team or the doctor to talk about these things, because it's all going to be written down in reports and things. And people, if you don't tell your service coordinator when they ask you what's happening at home, oh, everything's fine, nothing new. What can the coordinator talk about in a report, So, but if there's information in the IPP about behaviors that are happening, I mean, that is all really good information. So you need to speak up. You need to talk about things that are happening. And there may be other sources of evidence that mom can gather, but this is a pretty good list of things for her to start gathering. To show what? To show that Emilio's disability makes him non-self-directing, and that he requires 24/7 supervision. And for 24/7 supervision, she could get information from, maybe a declaration from the father who talks about, why behaviors during the night, or maybe, a teacher is willing to talk about the behaviors that the child exhibits during school. And hopefully that information is also in the IEP. Those behaviors are being addressed in the IEP through services. Mom may also want to prepare her own position statement. She may want to write down to the judge, just to give to the judge what she feels. She feels that he should continue with his protective supervision because he is non-self-directing. And this is the evidence, Your Honor, that I'm going to present. I've got this, this, and this, and this. And that he requires 24/7 supervision. And here's the evidence that I'm going to give you to present that. And by the way, here's the evidence. Unless you have witnesses, you're going to, along with your position statement, you want to give evidence. In any event, whether you're in person or you're going to appear by phone, you have to submit your evidence, what you want the judge to consider. And your evidence will be testimony, and it's going to be documents. So evidence is made up of two things. Now that we're doing a lot of phone hearings, I usually provide, you can upload all of your documents onto what's called the ACMS system through the state fair hearings. And you can actually look at your file, your electronic file. You can sign up, and you can look at your electronic file at any time. I'm just going to close this. And so usually the day before the hearing, when I have a phone hearing, I will submit my position statement and all my evidence. If I'm going to do an in-person hearing, I do that at the time of the hearing. And I'm going to take 3 copies of everything, one for me, one for the judge, and one for the county. The county will do the same. Well, the county will have given you the position statement, but the county needs to give their position statement and evidence to the judge also. The last thing that mom may want to think about is whether she wants to ask the social worker questions. Maybe there's, information in the assessment that's wrong or missing, or, the social worker says something that's not quite right. Mom should be ready to ask those kinds of questions. Maybe mom has witnesses that she's going to want to have testify, and so she's got to have her questions ready. There may be other people. Sometimes at these hearings, you've got the social worker and the supervisor. Sometimes they may bring in a nurse, and the nurse may, testify as to something. So you need to just know that at least of the people that will be there, you want to ask questions of. And sometimes the judge will ask questions too. The judge will ask questions of your witnesses. The judge will ask questions of the county's witnesses. There are judges that are very proactive during the hearing, and they are asking the kinds of questions that they need answers to in order to decide the case. Or there are other judges who are very laid back in the sense that they let the parties do their thing, right? So it can change, depending on the judge you get will depend the kind of hearing you get. Maybe very active judge or not so active judge. Invite the regional center to attend to help advocate or to testify as a witness. If you're not going to submit a position statement, at least make notes of what you want to tell the judge. And as you tell the judge something, you check it off, because the last thing you want to do is leave the hearing and say to yourself, oh my gosh, I forgot to say this. So you want to make sure that you make notes of everything you want to say. You want to make sure you cover all of your evidence. So really important. So sometimes what happens before a hearing or during a hearing is that the appeal specialist may say to you, why don't we enter into a conditional withdrawal and we'll give you what you want? That's the best case scenario. Or the appeal specialist will say, look, why don't we enter into conditional withdrawal and let us reassess. Now, mom can decide what she wants to do. She can just say, no, I'm going to just go to hearing, forget this. I've waited this long. Or she could say, okay, you can reassess for protective supervision. So the appeal specialist is going to draw up a conditional withdrawal. Mom needs to make sure she understands the conditional withdrawal and that what she's agreeing to. The appeal specialist should explain it to her. And let's say that mom agrees to the county reassessing him for protective supervision. Well, the county does that and they issue another notice, again, terminating the protective supervision. So with this, I want to say that just because you enter into a conditional withdrawal for a reassessment doesn't mean that you're going to get what you want, right? Now, you can always change your mind after you signed a conditional withdrawal and go forward with the fair hearing. So this is something that could happen during the hearing or before the hearing. Let's talk about the hearing. Who's going to be at the hearing? The judge, the appeals specialist, maybe the social worker in the case, maybe the social worker supervisor, you, the claimant, the person who requested the hearing. Maybe you have an authorized representative, someone who will represent you at the hearing. Doesn't have to be an attorney. And if you have someone representing you at the hearing, there's a form that needs to be filled out, which is called the authorized representative form. And you can get it here through this link. Witnesses will be at the hearing if they're going to testify in person. If you ask for an interpreter, the interpreter will be at the hearing. Okay, next one. The record. We always talk about the record. And what is the record? The record is all of the evidence that's going to be presented at the hearing, both oral testimony and documents. Everything that's said during the hearing, all of your testimony, everyone's testimony is recorded. And so why is the record important? Because if you lose at the hearing and you want to appeal the decision, your next step to appeal is to ask to go to Superior Court and be before a judge by way of what's called a writ of administrative mandamus. And the judge is not going to have a new trial for you. The judge is going to look at the record that was developed at the administrative law judge hearing to decide the case. Rarely will a judge allow any new evidence. So the record is really important if you're going to appeal. Sometimes when you're in the hearing, you realize, oh gosh, I forgot to bring this. I forgot about that evidence. I should have gotten something on that subject and I didn't. You can say to the judge, Your Honor, can you leave the record open for me to be able to submit evidence? I forgot that, and this evidence is really important because it's going to show this. And the judge can decide, yes, he or she will leave the record open for maybe a week to 2 weeks for you to do that. Because if you don't ask to leave the record open, at the end of the hearing, the judge closes the record, meaning no more evidence. But if the judge leaves the record open, then the judge is allowing evidence after the hearing to be submitted. Okay. What's the general sequence of events at a hearing? You walk into this small room and it doesn't look anything like this. This is TV in Superior Court. This is not an administrative law judge hearing. And no, they don't dress in robes or anything like that. The judge will be there. You sit on one side with your witnesses, and the county will sit on another side with the social worker and witnesses. The judge will swear in everyone who's going to testify. Then the judge reviews the evidence that the parties have submitted, the written evidence, and see if anyone objects to any of the evidence. And then the judge will decide on what evidence will be allowed to come in. And then the judge will turn to the county and say, explain what you're doing and why you're doing it. And the county in this case will say to the judge, well, we're terminating protective supervision because we believe Emilio is self-directing and doesn't need 24/7 supervision. And this is the evidence that we're relying on. There's this really good language in the IPP that says what we're relying on for this position. The judge, so the county has the burden of showing what changed between the last time that they granted protective supervision and this time. So if the county can't explain the change in position, like what changed then the county has not met its burden and should lose. So anyway, the county will explain what it wants to explain, and then you will have the opportunity to, then the appeal specialist may call witnesses like the social worker and question the social worker about, what they're doing and the that Emilio's self-directing, and talk about the evidence and why Emilio doesn't need 24/7 supervision. And then once the appeal specialist is done questioning his or her witnesses, then you, the claimant, the person who requested the hearing, excuse me, can
Bless you.
can cross-examine the witnesses of the appeal specialist. You can, try to, kind of ask questions like, why did you say this? Or why is this missing from your assessment when I told you this? You're trying to ask questions that will raise questions of the witness's testimony, right? Kind of like put a dent in the testimony of the county's witnesses. They're going to do the same with your witnesses. They'll try to cross-examine your witnesses and ask those kinds of questions, because once the county is done with their witnesses and you're done cross-examining their witnesses, the judge will go to you and say, and here in Emilio's case, the mom, and say, okay, why do you disagree? Tell me what evidence you have to support your position. And at that time, mom can talk about the written evidence and also call her witnesses or submit the declarations of the witnesses. And then, like I said, the appeal specialist will have opportunity to cross-examine your witnesses. Once all of that has happened, and by the way, I've been in fair hearings where the judge is very active in asking questions of the social worker, of cross-examining your witnesses, their witnesses, very, very active. And like I said, there are some judges who are very kind of laid back and letting people do their thing. After all the witnesses have testified, the judge will give instructions as to the next steps and the timeline for the decision. And if the judge left the record open for the county to submit things or for you to submit things, you need to comply. Because if the judge gives you until the end of the month to submit that evidence, that's it. If you don't submit the evidence at the end of the month, the record closes. You cannot submit any additional evidence. After the hearing, there's a decision. It's what the judge decided, and the decision will also talk about the evidence that was presented at the hearing and the evidence that the judge relied on to render a decision. Now, you may not know this, and this may be, not good news, but if in Emilio's case, the judge decides that Emilio, his protective supervision should not be terminated, the director of the Department of Healthcare Services, or CDSS, one of the two, I forget, can change the judge's decision. So in this case, Emilio's, the judge's decision can be alternated, but again, it's not just changing the decision. The director is going to have to explain why they're changing what facts and why they're relying, maybe the law, maybe the facts, to change the judge's decision. And it does happen. The decision also will tell you about your appeal rights. The writ of mandamus, you have a year from the decision to file a writ in court. You don't want to wait that long. And this is when you're in superior court and you win, you can ask the court to award you attorney's fees. That's a really good thing. And the recording of the hearing is kept by State Fair Hearings Office, and you could actually call State Fair Hearings and ask for the recording of the hearing, because when you're looking for attorneys to represent you in superior court, they want to see the record, which includes all the documents that were submitted at the hearing and the testimony, and the recording has the testimony. So it's really important. There's something else you can also do, and it's in the decision. It says you may be able to ask for a rehearing, another chance. The regulations say that you have to ask for a rehearing within 30 days of receiving the decision. You have to state why you're asking for another hearing. You have to state when you receive the decision, because they want to make sure you request your rehearing within 30 days of having received the decision. And if you're going to submit new evidence, you've got to describe the new evidence. You've got to state why it wasn't submitted before and why it's material, why it's going to change the decision. And then you'll either get the rehearing or not, but you do not have to request a rehearing to appeal your decision. You can go directly from the decision to the decision to superior court. You don't have to do a rehearing to get to superior court. Complying with the decision. This is the regulation on complying with the decision. Immediately upon the county receiving the decision, it has to initiate compliance. And within 30 days of receiving the decision, they have to submit a compliance report to State Hearings Division. Now, if 30 days go by and you haven't heard from the county, you can contact California Department of Social Services and file a complaint for non-compliance, but you can also do that with State Fair Hearings and say that the county hasn't complied with the decision. And then upon notification, that the county has failed to comply with the decision, CDSS will take appropriate action to ensure compliance. That happens sometimes when the county is kind of sitting on it. And we've come to the end of the presentation.